As a landlord, one of your biggest challenges is dealing with leaseholders who breach lease covenants. Today we'll break down what you can legally do if a leaseholder breaches the terms of their lease. My name is Sophie Campbell-Adams. I'm a solicitor and director at Britton and Time Solicitors. I've been a qualified solicitor for about 5 years now, and I specialise in property litigation, namely landlord and tenant disputes. Covenants can be positive, such as maintaining the property, or restrictive, like not subletting or running a business on the property. Typical breaches include failure to pay ground rent or service charge, making structural changes without permission, causing nuisance to neighbours, or letting through Airbnb or other short-term lets. Before taking any action, make sure the breach is clearly documented. This means keeping written records, gathering witness statements or neighbour complaints, or taking dated photographs. You'll need this if you pursue enforcement through a tribunal or a court. It's also important not to do anything that may waiver the breach or waive your right to forfeit. This often is accepting rent or accepting payment of service charge. There is the option to forfeit the lease. However, this is often a remedy of last resort and is often disproportionate. Instead, you may wish to consider the alternatives. Get the leaseholder to rectify the breach through informal discussions or mediation. Ask the court to grant an injunction to either stop a breach or an order for specific performance, forcing them to comply with the covenant. Seek compensation for the breaches, especially if they've caused loss. Rectify any breaches yourself if you can, and seek the cost from the leaseholder. A solicitor can help you decide the best route forward depending on the terms of the lease and the breach itself. If those alternatives have been exhausted, then the only option may be to forfeit. To begin the forfeiture process, you must first serve a Section 146 notice detailing the breach and giving the leaseholder a chance to remedy the breach or risk losing their lease entirely. But be careful, you must have an admission from the leaseholder as to the breach, or you must obtain a determination from the tribunal first. Courts and tribunals expect landlords to act reasonably. Rushing to evict a leaseholder or skipping key legal steps can end up costing you more in the long run. Make sure to always follow proper procedure and seek legal advice before taking formal action. Breaches of lease covenants can be frustrating, but as a landlord you have many options. From legal notices to tribunal applications, the right approach can help you enforce your rights and protect your investment. If you're dealing with a breach or want to better understand your rights as a landlord, Britton and Time Solicitors are here to help. Get in contact with us today for advice tailored to your situation.